The following program recognizes that the journey is everything. Unfortunately, too often, the journey is fraught with peril. Our aim is to help fellow followers stay safe through the journey. Accordingly, we are pleased to offer the following new service. Effective June 13th, 2022, all members of the following are entitled to free Lizard Man insurance. Any follower who succeeds in verifying that they were victims of an attack by a lizard man, lizard woman, or lizard people of any gender are entitled to a complete refund of this month's membership. In the event of an attack by a lizard man, lizard woman, or lizard child, kindly notify our claims department and forward a $99 processing fee so that we can settle your claim as expeditiously as possible. Thank you. Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic, the dominator of X Spaces. I love hanging out there. I love going in there against all these lefties and just dropping on them a splash of reality. Here's a splash of reality. I was on Mario Spaces early this evening. Part of the reason I was late. I apologize for the late start time tonight. But I was on that space, and they were sitting there trying to figure out, where does the Democratic Party go from here? Where do they go? What are they going to do? What's the plan? What's the plan? And some folks said, hey, I got it. Kamala, the answer. Kamala the answer. That's going to be her new nickname, Kamala the answer. Because when you have a question means you need an answer to the question. Because questions need answers. And if we don't answer the questions, all we're left with are questions that are never answered. So that's why we need answers to the question. And that's how she should be introduced all the time. The Kamala, the Harris. What is with this? I got something on my lens here. That's not good. That's not good. We're going to go lens free for a little bit here. But we're not going to do that very long because I got to take care of some folk here. As my recruiters have been working very, very hard at work. Very hard at work. Bringing in people into the fold. It's not easy. You inspired tonight's intro because I wanted people to be reminded about the value of lizard insurance. No lizard people are going to be disrupting your membership here. I know a lot of people are concerned. They have concerns, and that's why I'm saying, look, an attack by a lizard person entitles you to a complete and full refund. I will qualify for purposes of this insurance as offered in the intro that I will certainly count Kamala Harris as a lizard person because there's very little evidence that she's human. So she very well might be one of the lizard people. I don't know. Lizard child. It ain't red, but that was funny as hell. No one heard that war horn but me. But I'm gonna drop it again. Oh my god, that was great. That was so good. Let me give you the war horn you deserve. Where are you? All right, now you'll hear it. This is my lizard insurance process. $75. We have to process your claim. We have to process your claim. That's good. That was really, really good. We need to unburden ourselves with Kamala. We do. But before I get to that, yes, we do get lizard people insurance. It's very important. You can't have enough insurance. You can't have enough insurance in today's day and age. All right, so where was I at? Oh, yeah. So what I wanted to get to, this is very weird for one reason or another. I don't see the first person who gifted, which was Mary. I saw Mary did it. I don't know why I can't bring up that Mary gifted, but she did get 5 Good Lawgic memberships. And since I can't pull up, I'm gonna give her the gong, and give her the war horn. God bless you, Mary Coppola, bringing 5 new members to the following program, including Muffin Rando, Bifrons, Grifty, Beatrix, Carol Myers. Basically, everyone who you all I know are well aware of what the following is. You've been here. This is not your first rodeo. You've been here before, But I just wanted to remind you to kindly issue gratitude to Mary Coppola for the very generous gifting of a membership to you to the following. And I hope that your time here in the following is a time of great personal growth, because that's ultimately what life's journey is all about. So welcome to the following. I also want to welcome those of you from Winning Reality who were just brought on over here. Thank you, Winning Reality. That was very kind of you. I appreciate that. Who else do we get in here? I saw that there was one other. I saw our queen was busy. Oh, really? You're not gonna let me see who it was? You're not gonna let me see who it was? It was even in that chat. That's not cool. That's totally not cool. But God bless. Queen of Recruitment, Bella Stella, gifting 10 more Good Lawgic memberships. Unfortunately, YouTube being as YouTubian as possible. Like fallopian tube type of YouTube. This is what's I don't even like this is just wrong on so many levels that I can't scroll up and see who it was that Bella Stella gifted those memberships to. So I am going to just acknowledge and remind everyone we should have like a group applause. If you're in the chat there, I think it's appropriate. Just drop a little clappy hands. I don't know if you can find that on your keyboard. I can never find that on my keyboard. I see the 2. I have a W. I have an M. There's a V here. I have something that says Alt, something that says page up. I don't have clappy emoji on my keyboard here. But if you can find it and you can drop her claps, I think that would be appropriate, because she is. Look at that. Some of you actually found it. Nice. God bless, and that's all for you, Bella Stella. All these fine folks. God bless you, Queen of Recruitment, Bella Stella, bringing in 10 new members to the following. The following is not at all cult type of cult. It's not. It's definitively been proven. Has been proven. We've been tested. For is this at all a cult type of cult? And no, it's a gathering. Like-minded individuals looking to engage in community unity and studying some leadership training so that they can grow towards higher levels of personal growth. And you can all thank Bella Stella for that. The Queen. All hail the Queen. Okay, what do we got tonight? What we have tonight. Do you remember Uncle Floyd? He's sick. I'm sorry. That's unfortunate. I hope he feels better. I don't know what else to say. I hope he feels better. Thank you for the super sticker, Tammy. Okay. Tonight's going to be a little bit of a legal show. It's going to be a little bit of a legal show, but I'm going to try and make it as digestible as possible, because I know that the problem with the law is that it's very legally, it's very legalese. It's very alienating to the common folk. By common folk, I mean those whose brains have not yet been poisoned by law schools. So, the elitist snobs referred to as the common folk, but it's really the blessed ones who haven't been poisoned. It's almost like you haven't gotten jabbed. You haven't gotten jabbed with law school. You haven't been jabbed with law school yet. So you don't end up sounding quite as much like a douchebag, which is certainly one of the afflictions, is one of the common side effects of going to law school. Common side effect of law school is you will sound like a douchebag. Anyway, certified 99.94. It was clean as ivory. Our cult's tax exempt might want to reconsider. I'm glad you actually, I know you're making a joke here. I'm glad you brought this up. Because I do need to express my apologies with respect to locals, which is goodlogic.locals.com. Many of you have expressed issues with your subscriptions. So what happened, I don't know why this happened. What happened was I made, and I'm not going to go into detail about this, but I had to make change as far as like payments and how that was being structured on my end. And when I authorized those payments, for one reason or another, locals interpreted that as, let's just mass cancel a whole bunch of folks' subscription. And I don't know why it did that. There was no warning that was going to happen. I never would have done this if I thought something like that could happen. And I feel terrible. There's certain people have been trying to reach out to me saying, my subscription was canceled. I was like, I don't know what the heck they're talking about. I don't run any of that stuff. And then there were more and more people who were complaining about it. So I reached out to locals to try and have this remedied so that this gets sorted out. Now, I will tell you this. A couple of things I want to tell you about locals. All of you know that my general standing policy is that locals is an area which I basically partition away so that in case YouTube ever decides we're done with this guy, that I at least have some access to people who support me. I'm interested in encouraging me to be able to live while doing what I do. So that's why I have local set up there, and it's sort of like a little hub for people, which they acquired the nickname Diggers, and it's a hub for people, and where I will announce various appearances that I'm making. So those people who are interested in finding me will find me there, and I try and provide some exclusive content there as well. I plan on doing a show on there tomorrow. The subscription fee is designed to basically serve as like a museum gatekeeping type of thing. I certainly don't want to exclude anyone, and that's why I very happily offer anyone who doesn't have an entertainment budget, because it should be coming from your entertainment budget, that I will happily gift you free access to everything. But it's basically a little nudge to push people to support, if they can, at $5 a month. The way I structure that is, for those people who cannot afford it, is I basically go through 6-month periods, and I'll set it up on January 1st. I'll set up 6 months worth of codes. Okay, I'll tell you all now. The code was, for the last 6 months, was not at all occult. That was the access code. Any of you can use that right now. Not at all occult. You can only use a code once, and it's good for a month. So I built in not at all occult 2, not at all occult 3, not at all occult 4, 5, 6. That code will expire on July 5th, I think, or 4th. I'm not sure. I know I put it for around Independence Day. So that's not going to work next week. Any of you who are interested in signing up and checking out the channel, come over to goodlogic.locals.com. You can get full subscription access. Those of you who were knocked off and are not presently subscribed, you can use that code and have access for the next month. And I'm happy for you to have that. What I plan on doing is after July 4th, so I'm going to be building for those people who cannot afford subscription, I'm going to build another thing, a new code catchphrase that will be, whatever it is, similar to Not At All Occult, but completely different. And then I'll have 2, 3, 4, 5, 6, so you can use that each month. The reason I run it for 6-month periods is because I'm hopeful that people who cannot afford it will find themselves on their feet 6 months from now. So this way, if they want a new code 6 months from now, just ask. I'll give it to you again. We can keep going through this literally for the rest of my social media career. I'm totally fine with it. I'd be happy to do it. So it's no skin off my back or anything like that. I don't want anyone to ever feel uncomfortable asking me, because I'm not upset with you. I'm not passing judgment on you. I'm not passing judgment on anybody. And it's not that I'm not passing judgments. I literally don't even remember who I give the code to 2 days after I gave it to them. I'll be like, oh, you were like, because I'm just doing my thing. And I want to encourage people to help support me, but I'm not sitting here looking at this person or that person or whatever. So that's why I feel like 6 months is a nice long stretch. I know some people might have first asked me a month ago, so now they're going to have to ask me again, and you will have to ask me again. But I'll give you a code that'll work for the next 6 months. I haven't even built the code yet. I haven't built the code for July through the end of 2024. But yeah, so that's essentially how I plan. That's what I plan on doing. And I also promised, and I will keep true to this. I'm going to give those of you who have been affected, I'm going to give you an extra month. And I have to figure out how to do that. Because I know some people are not going to see this message that I'm saying now. And then they might not know to use Not At All Occult for a month. And I'm not sure if that would help the people who've paid annually. So those people that paid annually, I want to give them an extra month. Because I feel bad that even though I had no idea that change I was making my back end of production could impact you, it seems like it has. So I'm willing to accept that, and I'll be happy to give extra access for a month. And I genuinely apologize to any of you who are hassled by it. I'm sure it was probably very frustrating, very aggravating. So I'm going to do everything I can to remedy that as soon as possible. I haven't heard back from locals yet. I reached out to them via email and then by their communication notice. I don't know if I'm going to hear from them before Monday because, holiday weekend and all. So, and those of you whose codes are expiring and need to have a new code, so just hit me up and I'll create that probably tomorrow is when I'm going to create those new codes for the next 6 months for those of you who cannot afford it. So I got all that out of the way. I think that covers everything. If you have any questions, feel free to holler at me. All right. We got this. I was jabbed by law school, hence my 35-year left leaning. Yeah, that would explain it. That would explain it. K-Pick, member for 2 months. Hi, cult leader. We are not a cult. Not at all a cult. Not a cult. Welcome, new member, Sonata Girl. Sonata Girl. Welcome aboard. Welcome to the following. I don't recognize the name. That doesn't mean you haven't been here before. So I'm just going to let you be aware, because a lot of people get confused about this. I'm not the leader of the following. You just joined the following. I am not the leader of the following. Okay? Say it with me. Joe is not the leader of the following. Okay. But welcome. Thank you for joining. There's a special handshake for joining. First of all, it's not at all a cult type of cult. Obviously, there's a special handshake. obviously, we don't discuss it outside of the following. So I don't know what to tell you. I don't know what to tell you, Brooks. I'm sorry. I see a little S there. So I'm supposed to tell you. But, if you know, you know. And if you don't, I don't know what to tell you. Let's get into the law tonight. Let's get into the law. We got stuff to cover. We have things to do. And I want to share with you all my perspectives as far as this lawsuit, which I'll tell you right now. When I first heard about state of Missouri versus state of New York, I was very skeptical. Very, very skeptical. I started reading through it. I still have questions. Still not sure it's going to work. But I think that it merits an assessment. I'm going to talk about what is logical philosophically under the law versus is what the law says, and then there's how the law works. These are not necessarily the same. Okay. Let's start this thing up. Let's get the show on the road. This is, I don't need that. In the Supreme Court of the United States, state of Missouri versus state of New York, extreme close up. Right. Just showed my age with that one. Motion for leave to file bill of complaint. Pursuant to 28 U.S.C. 1251A, and this court's Rule 17, the state of Missouri respectfully seeks leave to file the accompanying bill of complaint against the state of New York. What is 28 U.S.C. 1251A? You might be wondering that. Here's your answer. The Supreme Court shall have original and exclusive jurisdiction of all controversies between two states. That's 28 U.S.C. 1251A. That the Supreme Court has original and exclusive jurisdiction of all controversies between two or more states. The very first video that got caught notice, many of you will know that I did, was the case of Texas versus Pennsylvania. And I was outraged that the Supreme Court said, we don't need to hear that case. We're not going to listen to it. And one of the reasons I was very bothered by it is because the Constitution specifically says this is not a Constitution. This is a statute saying that they have original exclusive jurisdiction. But it says they shall hear all controversies between states. Shall is a directive in the Constitution to the Supreme Court. There's not many directives, not many mandates the Constitution puts on the Supreme Court. That certainly seems like one of them. Doesn't say may. They read it as may. The very next section says the Supreme Court shall be paid regularly, commensurate with their services. They don't interpret that as may, but apparently shall hear controversies between states. They interpret that as may because they said we don't need to listen to Texas versus Pennsylvania. We can deny cert. I thought it was illegal for them to deny cert. I thought that was wrongful. I don't think it's their question. I might not like the answer to the decision that they give, but they have to make some decision, as I understand it. But this is the statute that's specific. It's more convenient to cite to a statute, and that's what he does. Andrew Bailey refers to that statute. Pursuant to U.S.C. 1251A and this court's Rule 17, the state of Missouri respectfully seeks leave to file the accompanying bill of complaint against the state of New York. Missouri seeks modest relief. What is the relief they're seeking? They looking to overturn the convictions? Looking to say convictions are gone? No. And this is very important. This is very, very important because the nature of the relief that they're seeking seems relatively minimal, and that I think greatly enhances the possibility of their success. Because when I first heard about this, I was like, no. When I looked at the relief they're asking for, I'm like, okay, that I can see. That's got a little bit more possibility. What are they seeking? A stay of New York's gag order and impending sentence against Donald J. Trump during the 2024 presidential election season so Missourians can participate in an election free from New York's exercise of coercive power, limiting the ability of Trump to campaign. So, They're saying we don't want to have the gag order in effect until the election. And we don't want him to be sentenced until the election. Because if you sentence him, you might restrict his ability to travel and be heard at various events. And we also don't want the gag order to inhibit what he can say while he's attending these events and trying to campaign. As set forth in the accompanying brief and complaint, the actions by New York have created constitutional harms that threaten to infringe the rights of Missouri's voters and electors, namely the gag order and impending sentence unlawfully impede the ability of electors to fulfill their federal functions. Really? See, this I'm trying to figure out how does that work? If he can't speak, you can't do your function? You can't read through it quickly and just be like, yeah, it's in our way. And I understand this. I want to be very clear as I'm going through this. There's a lot of things philosophically we sort of need to think about here. First and foremost, does the nature of the crime, being a relatively low-level crime compared to, let's say, if he had been convicted of a violent crime. Like, imagine if New York State had convicted him of murder. Would that change? And he still was the presumptive GOP nominee. Would that affect the state of Missouri's right to intercede? And if the answer to that is yes, well, if it was a murder charge, he was convicted on a murder charge, then they would have no right to intercede. I can understand how in your heart it feels like it should be different, right? It's like, well, this is what they're going to label a bookkeeping crime, and I think properly so. But you sort of have to understand from the eyes of the law, okay, so what's the cutoff? What if it was not murder, but it was arson, thievery? He was convicted of thievery. You sort of need to set a line as to what makes something a serious crime that you're going to say, well, if it's a serious crime like murder, in that case, Missouri would not be allowed to intercede. But if it's a less serious crime, like bookkeeping fraud or something, accounting issues, then they do have a right to intercede. And like I said, your gut probably says there is a difference. I don't know. Some of you may be saying, no, even if it was murder, we should be allowed to hear from him. And they shouldn't have any right to step in. Really? I mean, you sort of, if it was mass murder, if he had, if he had gone crazy and still he was somehow the GOP presumptive nominee, you might say, Joe, that's a far-fetched type of perspective. I'm trying to help your brain sort of cogitate about how the law, excuse me, how the law needs to sort of set down guidelines so that we know where things are applicable and where they are not. Because if we can set up these guidelines, then we can better understand the logic as to why it is that they have a right or do not have a right to ask for the relief that they're asking for. So that's why I sort of throw these philosophical questions at you, because the law is engaging in philosophical type of questions on a very frequent basis. As far as just understanding, it's sort of trying to come to some sort of logical conclusions based on statutes and prior cases. So if we're going to set down that Missouri does have a right to intercede here, we're not just worrying about, okay, can Missouri do this now? We have to sort of say, what is the reason we're allowing them to do this? And would we similarly allow them to do this, a different state to do this 20 years from now with a different candidate when that state has potentially convicted someone of murder, mass murder? So, and, how would that be distinguished from this time when we are allowing them to intercede? I think that's the healthiest way to sort of, especially when you're looking at Supreme Court, sort of enable, sort of put yourself in their shoes and recognize what they should be thinking about. I'm not saying they are thinking about it, but what they should be thinking about, given their role in our judiciary and their role in setting precedent, not just deciding and making a determination for how things are going to work in the next 6 months, but how things are going to work in the next 6 decades. And it's a whole different philosophical mindset, which I think a healthy Supreme Court should be mindful of. Because one day, our grandchildren are going to be looking at decisions that are being issued today as, wow, those landmark decisions, those significant decisions. So you sort of need to establish for future generations why this is okay here, why we're doing this. So when I look at this over here, I see New York's gag order and pending sentence unlawfully impede the ability of electors to fulfill their federal functions. I'm like, wait, so the electors, so these are the 10 folks from the state of Missouri who are going to cast their ballot after the elections for one of the candidates. What is their function? They cast a ballot. They can't cast a ballot if one of the candidates is inhibited from being able to speak on certain topics. I don't even understand how that would be. Another way to engage in this exercise is imagine it was the other guy. It was Biden. It was their guy who was convicted. And now you had the state of California wants to say, our electors can't do their job because you have Biden under, you have a gag on Biden. Imagine Biden was not the current sitting president. You'd be like, what the hell are you talking about? Why can your electors not do their job the same way? That's how it's easiest to come to reasoned thought process if we can sort of take our emotion out of it by looking at it if the shoe were on the opposite foot. That's what I find at least. Jenny L., God bless you. Whoops, that's not the right one. Hello! Hello! Thanks for all you do, Joe. Like and sub. Amen. You guys want to know where my subs are at? I don't know what happened. Something weird is happening here. Something weird is happening here. Let me share with you. I couldn't even understand. I don't understand what YouTube is funky. It's a funky creature. I've been watching this thing all day. I can't even explain it. I left yesterday. I was at 99,060. Right now, I'm at what? What is happening? How is that possible? How is that even possible? That after my stream ended, I went up 60 people? I don't know if that's ever happened before. My theory is maybe the advertising that Uncivil did for me as a birthday present is kicking in. Yeah, you're all funny. Just unsubscribe as soon as I pull this thing up. It's an old joke. Maybe it's the advertising. I don't know. That's crazy. That's crazy to me. Because I recognize I was supposed to go down by 15. So I'm looking at I went up 75. I was supposed to go down by 15 or 20. Maybe the advertising actually works. I don't know. I was astonished. But yeah, if you can like and sub, I'd be appreciative. First rule of Fight. Well, never talk about Fight Club. Joe is the host of the following, which is pretty much the leader of the following, which is pretty much nope. Ben, nope. You see, you're not a follower. So this is why I can understand why someone who's on the outside looking in would reach improper conclusions like that. But I don't see the little S there by your name telling me that you're a follower. So maybe that's why you get very confused about this. And I can understand. Things are foreign and distant. Oh, it's very distant. What is that crazy culture out there with the following? What's happening out? I understand. But people who are members of the following, they understand that I'm a host, not the leader of the following, and that the following is not at all a cult type of cult. So, Joe, I tried to tell Tim Pool to have you on a Super Channel show. In perfect fashion, God distracted him with poker and Magic the Gathering talk. I tried. I'll tell you right. I appreciate that, Sun Wu King Kong. It's funny. I purchased a domain name. Early this morning. I couldn't sleep. I didn't sleep all night. I couldn't sleep. And early this morning, I was like, I'm going to purchase a domain name. And I called up this guy. Give you a quick story here. If you don't mind me sidetracking you with some stories along the way, because it is July 4th that we're coming into, and good stories are. I called up this guy who sells domain names because I wanted to buy the domain name the following. And I was like, that would be a perfect site for members of the following to come and congregate and, do what they do. There'd be certain merch that would be available, things of that nature. So I was like, let me purchase a domain name. So I called up this number and I got some British dude. His name is Wesley. And when I'm talking to him, so I was talking to him about different domain names that I might be interested in because the following is .com is already taken. And he quoted me a price, which was more than I had an interest in paying. And I was like, wow, that sounds pretty steep. So I was like, that's not gonna work for me. Maybe down the road, but not now. So, and I told him I wanted him to understand what I do, and why I'm going with the name the following, so that he could better understand it. And so he's like, oh yeah, I follow some people on LawTube. He's like, who's that black guy with this is what he says. Who's the black guy who's got like the eye? So I said, Nate the lawyer. So he's like, yeah. I was following him during the Depp trial. So I was like, he's like, there's a bunch of LawTubers. And as soon as he used the name LawTube, I was like, you don't know who I am. You don't even know who I am. He was talking to me about Nick, Eagle Bites, and Nate, and all that stuff. And I was like, and he looked me up, and he looked at my channel. I was like, oh yeah, I know who you are. So the reason I was sharing this story is there was a reason. Oh yeah, I was talking to him, and he's like, you know what you need to do? He's like trying to give me advice on my channel. He's like, you need to go on Tim Pool. And I'm like, I appreciate the thought. I was like, that's a good idea. I'm gonna get to work. I don't know. Tim Pool, I think like I ran over his dog or something. I don't know what it is. Tim Pool is like, anyhow. But I appreciate you reaching out to him. I appreciate you reaching out. But Tim and I don't know. We got beef apparently. I don't know how, but somehow he must have beef with me or something. Some of this doesn't even make sense at a certain point. It doesn't make any sense. Let's get back to work here. So I'm explaining to you how I don't understand what they're saying here. That it's somehow interfering with the Missouri electors' ability to do stuff. I just don't understand it. New York's gag order and impending sentence violate the Purcell principle. What is the Purcell principle? That's what you should be asking. He says the gag order and pending sentence violate the Purcell principle. You should be asking that. That was a question I was asking when I read this. I was like, I don't know what the Purcell principle is. Apparently, it comes from a case called Purcell versus Gonzalez. Under the Purcell principle, courts should not change election rules. This is election rules during the period of time just prior to an election, because doing so could confuse voters and create problems for officials administering the election. Citing Purcell versus Gonzalez. Okay. In which the Supreme Court reversed the October 2006 of the U.S. Court of Appeals that the Ninth Circuit was blocking an Arizona voter ID law during that year's midterm election. District Law had initially denied the plaintiff's preliminary motion to block the law. Ninth Circuit ruling blocked the law until an appeal on the merits could be heard, in effect changing the rules for the November election. The Supreme Court said you can't just change rules at the last second. Now, changing rules, this is not, and again, I'm looking at this with a harsh eye. Is putting a gag on him or restricting him, is that changing the rules of the election? Feels a little bit like a stretch. I'm looking at this with a critical eye. I'm not looking at this to be like, yeah, get him, Bailey. And that's not because I'm not rooting for Andrew Bailey, the Attorney General from Missouri. Obviously, I am. I want him to be successful. I'm looking at this with a critical eye to see whether or not it's likely to withstand SCOTUS scrutiny. So he's going to have to explain to me more as to how the Purcell principle, which is saying you can't change the laws, election laws close to an election, means that this is not changing a law. This is changing a status of a particular person. And maybe you can say that Purcell it's similar to the Purcell principle. That I can swallow, but it's not exactly the Purcell principle. New York's gag order and impending sentence violate the First Amendment rights of Missouri citizens to listen to the campaign speech of a specific individual on specific topics. The right to listen is an interesting thing, which I've covered on this channel many times. I feel like I'm going over this a lot. It's not exactly the same as the right for free speech. I actually had a whole episode where I was talking about the right to listen. And is that a fundamental right or not? The right to listen. The example which we were talking about in that particular scenario, I said, let's put ourselves back in a 19th century mindset or an 18th century mindset. Okay, like imagine if there was all sorts of pamphlets that had been printed and were being transported to the Americas, and they were subversive to the culture and attitude of Americans, patriots who were living here in the year 1800. Let's say that they were subversive to the war effort in 1812. The War of 1812. The Revolutionary War, saying a British ship came in here and had all sorts of pamphlets discouraging the colonists from joining in the fight against Great Britain. And imagine that we had our Constitution then, which we didn't. But would the Constitution have banned the government from stopping that from coming in? Or could we say Americans have a right to listen? The same way if the French had sent a ship that was full of pro-Revolutionary War propaganda, that would easier to imagine is the Civil War, right? During the Civil War. So would it be illegal to have a ship come in that is fighting against the war effort to fight against the South, and to keep that out, those pamphlets out? Is the government violating your core rights because you have a right to hear, right to learn, right to see? And I don't think it's the same as right to speak. I think that's the conclusion I reached. It's definitely not the same. It's not as powerful as right to speak. There's a lot of things that we're banned from being able to hear. We're restricted from being able to hear. It's definitely not the same. And there are good fundamental philosophical reasons why it should not be the same, because you have a need to express yourself. You don't have a need to hear from everyone. It's violative of your own person to say you cannot express yourself. But it's not violative of your person to say you can't listen to that guy. It's really not the same. But it does feel as if it's certainly impacting that guy's freedom of speech. Anyway, what he's trying to build here a basis for Missouri to have an interest. Missouri respectfully submits that I'll tell you right now, these are three bit of a stretch type of bases. There's no powerful, yes, this is a winner. It doesn't mean they're not sufficient. I'm simply saying there's nothing here that I could be like, wow, how did this, if I'm imagining a scenario where the Supreme Court says, no, I'm not recognizing your standing, that I would feel outraged that is a complete abuse of misreading of law because of this element here, and I don't see that here. I wish there was something. I wish there was a basis. I wish that standing would just the notion of standing would fall into the river and sink down to the Leviathan and get swallowed up forever, because standing to me is bogus. Standing is stupid. Standing is absurd. It's ridiculous. The court should be adjudicating issues that are affecting people, even if it's not brought necessarily by a person or party who is the most affected by it or uniquely affected by it. I think it's ridiculous, especially when you have damages that are affecting large swaths of people. Then you're going to say, well, none of them is specifically harmed, so now there's no standing for any of them. So what? So people should be able to harm people en masse? By that notion, if you can release toxic waste across the entire country, well, none of you are specifically affected. You're all affected the same. None of you have claims against. I mean, think of how ridiculous that sounds. Are you specifically affected? If someone was releasing radiation on a literally global scale across the entire country, how are you specifically affected? Why are you a proper plaintiff? Why are you? It's like, what? It sounds so stupid. It sounds so utterly asinine. And that's why I think that when people raise standing issues on the fact, like, well, why does Missouri have standing? Well, you know why? Because all of America is harmed, and someone's got to bring it. So I think standing is a joke and stupid and philosophically empty. That being said, I'm sufficiently trained in the law to know that standing is an issue that every court is going to consider, probably for the balance of my years and well beyond that. Standing is not about to go. The issue of standing is not about to go away. So it is rightly or wrongly, whether I'm correct in my criticism or incorrect, standing is here to stay for the foreseeable millennia. And accordingly, you have to meet what standing is. The problem with standing issues is it feels so arbitrary as to when does someone reach this yardstick that you have standing. It feels very, very arbitrary. And that's part of the things I don't like about it. It feels like the exact opposite of justice, because you can say this person has standing if you're so inclined, and you can say almost nobody has standing if you're so inclined. To me, it's almost like the judiciary's loophole as to how they can act arbitrarily and capriciously if they're so inclined. So that's another issue I have with the notion of standing. So now I'm sitting here and I'm doing a 2-hour live stream where I'm trying to walk you through whether or not Missouri has standing. So I'm giving you that backdrop so you have a better understanding as to my frustration with standing and how difficult it is to predict when you're talking about things that are literally arbitrary. And it really depends on the judge who's hearing it. And we need to consider who these judges are because it is so arbitrary. Missouri respectfully submits that the foregoing violations establish considerable harms to voters and electors in Missouri, will be precluded from fully engaging with and hearing from a major party presidential candidate in the run-up to the November election. These harms are a direct consequence of New York's calculated, unprecedented decision to prosecute Trump for alleged bookkeeping offenses. Just months before the presidential election. This court should grant leave to file the complaint and stay any gag order or sentence against Trump. So this that they're seeking, the nature of the relief that they're seeking, like I said, this is it right here. Stay any gag order sentence against Trump until after the November presidential election. When you look at that, you sort of say to yourself, okay, Is that really stepping on New York's toes that significantly? Is it really like, oh, instead of implementing your justice in July, that we're going to offset that and say you're that for the next 4 months you're going to hold off in implementing your justice? Is that really killing you? After November, go ahead, do what you're going to do. Do what you're going to do. Wait till the election so that this way he can campaign. It does not seem like it's really doing that much, certainly with respect to the sentence, especially because we know Judge Mersham pushed off the July 5th, the July 11th date. I'm not even sure if he said what day he's going to be coming in here. So with respect to sentencing, it does not seem like it's that significant an ask. The question is with respect to the gag, because the purpose of the gag is so that he's not going to be causing harm. So if you're putting a stay on the, and assuming you're saying that he could be causing harm, so in that case, a stay on the gag kind of vitiates the entire point to the gag. So really their ask here is very, very different in my mind when I'm looking at this, that the ask on the stay for his sentencing seems like an easier ask than an ask on the stay of the gag. Because every day he can be violating the gag. Any day we're waiting to sentence him. So, okay, instead of him serving a sentence in July, he'll serve it, or in August, he'll be serving it in theory in December. So where's the harm? You're getting him to serve his sentence, meting out justice. But with respect to the gag, if you take the gag, the reason for the gag, the purported logic that's for the gag that I've been fighting my tail off to get rid of, that is the purpose of the gag, is to protect people. So if you put a hold on that, how is that not going to completely wipe away the whole purpose and benefit of this very, very, very necessary gag? So that's a bigger ask from my mind. All right. We get some of these. Oh my, I missed this. Molan Labe, I apologize. You waited for the last 10 minutes. I hadn't even seen this. Off topic, but with SCOTUS Prez immunity ruling, does Trump have an argument for double jeopardy if charges have to be refiled or reworked due to improper evidence? Any legal exposure for the prosecutors for improperly breaching Trump's attorney-client executive privilege? Okay, so there's a lot to unpack in what you're asking here. So we just got the immunity decision that came on Monday. Does he have an argument for double jeopardy if charges have to be refiled or reworked due to improper evidence? So this is an interesting thing, and I do want to just caution you. I'm not a criminal defense attorney. I always understood that double jeopardy, to me, would not attach if they had to have a do-over. When I first learned of the concept of double jeopardy, in other words, double jeopardy is, I always understood it to be like, okay, if there's a mistrial, there's no double jeopardy in doing it all over again. So if you're declaring a mistrial, that would be no double jeopardy. When we're talking about the YSL case and the possibility of a mistrial based on that meeting that Judge Glanville had with Copeland and the DA and his subsequent actions thereafter. So I was talking with several criminal defense counsel who were saying because this mistrial would be caused by the wrongful conduct of the district attorney, that is a basis to say that this mistrial should lead is all the fault of the state, and now it would fall into classification of double jeopardy because he already had to go through this whole thing, and the only reason he's going through this a second time is because the state was, very recklessly negligent, if not willfully malicious to this defendant. And in those circumstances, the mistrial could lead to a finding of the guy walks, because to prosecute him at this point, now that you, the DA, screwed up, that now creates a double jeopardy issue. But what's pivotal there is, from what, and this is, again, I'm not a criminal defense attorney, this is based on conversations I've had with various criminal defense counsel. So what's pivotal in that scenario is that you have that negative behavior by the state in the form of the district attorney's office, which is what now makes that mistrial turn into double jeopardy instead of just being a do-over. In this context, seeing as how the reason for the mistrial, if such a mistrial were to be granted on the basis of there's now a finding of immunity that we didn't recognize, I don't think you could label that wrongfulness by the state or the court. However, in stark contrast, if Judge Merchand's orders are overturned, meaning the way he conducted his jury instructions is deemed by, let's say, the Court of Appeals to be terribly unconstitutional, that could, because I think if it's a foul up by the state or potentially even the court, that's a really gross foul up, that could have now a mistrial, which would lead to being the guy walks, the defendant walks. I hope that answered that first question. Your second question, I'm going to give you this also again. Any legal exposure for the prosecutors for improperly breaching Trump's attorney-client executive privilege? In theory, yes. In practice, no. No one's going to go after them. In theory, you engage in wrongful behavior, you can be faced, sanctions and anything of that nature, no matter what your position is. In reality, no, they're not going to face anything. So, thank you for the generous super chat. Trim and Stiglitz, Joe, I would like to join the phone, but I don't have it as an option. The link isn't working. Only cult would make it hard to join. It's not meant for everyone. It's not meant for everyone. Do I have it in my description? I do. If you look down in the description, it says join this channel to get access to perks, which is not really true because you don't really get access to perks. There's no I don't know why I wrote that. But right below that is a link that you can join. You can click and join. I guess the perks is that you're part of the following. That's really that's the main perk. I do list certain perks there. What's really funny is I have for high priests an offer there, high priests, because high priest is $100. Those who pay to the following $100 a month. So I even forgot that I put this in here, that if you pay $100 a month, I'm going to give you a 10-minute call, Zoom call, one-on-one, which I didn't remember putting that in. And then I said, if you do it for 2 months, the second month, I'll give you another 10 minutes. And the third month, I'll give it to 30 minutes if you're a high priest for 3 months. And it says capped at 30 minutes. I'm not going to, someone who's here for a year, I'm not spending 2 hours of my life. I'm not doing it. I'm not doing it. But I capped it at 30 minutes. But yeah, so that was an offering that I made that I totally forgot about. And someone reached out to me on the next, and they're like, Joe, I signed up I paid the $100. I want my 10 minutes. And I was like, what the hell are you talking? Apparently, I wrote that when I was drunk, very tired, late at night, but I am going to honor it. And I'm going to be having that phone call with him, a Zoom call with him next week on Monday. If I make an offer, I'm going to stick behind it. Joe, we're a different demographic than Tim Pool. Perhaps, I guess. You're far more intelligent, probably. Joe, so who would make a good attorney general? Yours truly. Ron Coleman said he put in a good word. Yeah, he did. That's my point. Ron Coleman spoke to like directly pitched for me to Tim Pool and his staff. And I still haven't heard from them. So I think they definitely know who I am, and it seems as if they made a willful choice to say. So it could be his Jewish quota is getting way overdone after Ron and you. He needs schmaltz. Possibly. MLS, how are you, brother? If you try to bring a lawsuit from the position that you have a right to hear someone's speech, I believe it will be quickly disposed of with lack of standing judgment. Yeah, because you don't have a right to hear. And that's That's a major problem. That's a major problem here. That's my point. That's why I'm saying I think they have real standing issues. I think they have real standing issues. There's a law they're talking about as the gag, because once it's done, it can be applied to anyone making it a law. The law they're talking about is the gag, because once it's done, it can be applied to anyone making it a law. That's exactly who are you talking to, Wesley? I'm the guy who filed a lawsuit against Judge Merchan trying to overturn a gag specifically because of this concern right here. This concern right here is why I filed that lawsuit. In fact, I'll even pause right now and give you an update. You want to know an updated status there? Those of you who might have forgotten, I lost at the level of the first department, which is our first appellate level. I lost there. I filed notice of appeal, as did my attorney on behalf of Good Lawgic. I filed personally on behalf of myself, pro se, to the Court of Appeals. And we're waiting to hear back from them as far as scheduling and timing and then, briefing, things of that nature. So that's where I'm at right now. But we have filed our notice of appeal, and we believe with respect to the Court of Appeals. So I spent a long time dissecting this with Ron Baruti. It's a very confusing thing as to whether or not I can go to the Court of Appeals as of right, or I need to have with their permission. The way I would get in as of right is that New York has a right to come in there as of right if you're challenging a constitutional issue, whether it's U.S. Constitution or state constitution. To me, I think that this clearly falls under that. But they sometimes can be selective and say, this is not really. We don't deem it to be that, and they might bounce me out. It could happen. Who knows? Are you getting your amicus ready? Hashtag. Well, there's your answer. There you go. My amicus to their filing. That's an interesting thought. I can't file there. Ron can, though, probably. That's a very interesting thought. File an amicus brief. I like this idea. I'm texting Ron. I just asked him. Sorry. I just asked him if he want to file an amicus brief on behalf of Good Lawgic in Missouri, New York. I sent him that, and then I just realized, oh my God, I'm literally texting him at midnight on July 4th. I'm such a bad client. Oh my God. The audacity of a client to be texting his lawyer at midnight on July 4th. Well, look, it's for freedoms, okay? It's for freedom. They may take our lives, but they cannot take our freedoms. I don't know. Fireworks going off, 1812 Overture and Good Lawgic. That is what America is. That is America. We are America. Amen. Surely in an election, being prevented from hearing a delegate you may vote for, if you could hear, does impinge your rights. Yeah, that's the argument they're going to make. Look, one of the things I criticize Trump about, and why I said my arguments are stronger, is because political speech is the most protected speech. The reason political speech is most protected speech is because of exactly this, right? We want to be able to hear from our candidates and be able to get different ideas and understanding so we can make informed decision. It is for the listener. The reason political speech, so this is in to point out to you, where you say if you bring a lawsuit in position, you have a right to hear someone's speech that you believe will quickly dispose of with lack of standing. I think in many cases that's my first reaction to. That's the first reaction I have. Like, you don't have standing for that. But then we have this concept that political speech is the most protected speech. And the reason that political speech is the most protected speech is for the benefit of the listeners specifically. Not because that's something that's, unique. People need to express themselves about their politics. No, it's because we want the public to be informed. It's specifically for the listeners, if you think about it philosophically and logically. So, with that being said, here's the problem. While we've heard over and over again that political speech is the most protected speech, I am unaware of any court decision which says, and because it's the most protected speech, we are going to give it this added protection. It's going to be added protection in this specific way that other speech would not be protected. But because it's the most protected speech, now we're going to protect it and not allow you to affect it in this way. So it gets this nice highfalutin respect in the eyes of the court that it's such important speech, but it's never quantified how exactly what we're going to do for political speech that we wouldn't do for any other speech. It's just a nice phrase to throw out there in the middle of chastising about something about general speech, to throw out some phrase saying, and this is political speech, which is supposed to be the most protected speech. Okay, but is there a way that it's more protected than other speech? And perhaps this is an opportunity for the court to say, this is the way. This is the place right here. Perhaps. I don't know. Because there's little precedent, if any. I'm unaware of any precedent where they said, because it's political speech, we're going to give it this added thing that we're going to help it for the listener. We're going to give the listener a standing. That would be a novel decision by the court. I believe it would be the correct decision. I personally think it makes sense when we consider the reason why we're protecting political speech is for the listener. But that would be significant precedent that has not yet been. That you're driving through fresh snow here. Okay, this is not a beaten path. This is you're going off the path in something that is logical, should be, but does not yet exist. Midnight, July 4th. If the founders and our warriors didn't work today, we wouldn't be free. Thank God for them all. Amen. Not just for the. It's not just Americans that should be thanking them. It's the entire world should be thanking them, because so much of, as far as what the world learned about what freedom is, came from our forefathers, our nation's forefathers. So what better to be going through here than the right of political speech? I'm going to really be fixating primarily on the standing. So, but I'm going to go through the nature of the action. And then before I get to I'm going to skip past the facts. And I'm going to jump right into the standing issue. Missouri brings this action against the state of New York, and for the cause of action says the following. Missouri seeks to invoke this court's original jurisdiction to make just one modest request: temporarily stay any gag order and sentence imposed by the state of New York against Donald Trump. Missouri requests that the stay lasts until after the 2024 election. So 2024 election, I think, is November 5th, November 6th. Go New York, go do whatever the hell you want to do. Just don't screw with us for the next 4 months. This modest request imposes no harm in the state of New York, but It ensures that voters in Missouri and across America are able to make their voices heard this November without one state interfering with the ability of everybody else to hear a major party candidate campaign. Now, I believe that this is logical and fair. And that if we're looking at the Supreme Court as a court that's looking to impose fairness, that this is a nice argument. But as Law and Lumber pointed out to me, that's not how the Supreme Court operates. They don't really care about fairness. They're not supposed to be focusing on fairness. They focus on what the law says. Does the law say they should do this or not? New York's gag order and impending sentence against Trump interfere with his ability to freely travel and campaign, and interfere with the right of Americans everywhere, members of the Electoral College in particular, to hear Trump's political speech. See, I don't know why he's making a big deal about the Electoral College in particular, especially since the will of Missouri electoral. You mean the Missouri electors? Okay, I guess they're saying because they're the ones who are going to be carrying out the vote, which is the official, which officially confers title. Okay. All right, I'm okay with that. Nothing is more destructive to the health of our democracy than distrust in the outcome of the election, and yet New York has brought transparently weak charges for the transparent purpose of trying to impose political damage against Trump and trying to restrain his ability to campaign in advance of election forecasted by the polls to be very close. Okay. So they're saying it's transparently weak charges, and its purpose was to impose political damage. So not as opposed to seeking justice, which I certainly agree with factually to be the case. I think it's difficult to not agree with that, but that's a finding of fact, which the Supreme Court doesn't really engage in the findings of fact. Like, how are they supposed to verify that? I understand we look at it, we understand, you and I understand that, but to reach that conclusion, that's what New York is doing. Is the Supreme Court supposed to sit as a fact finder to investigate as to whether or not these charges were brought for purposes of going after him politically to cause political damage against Trump? I mean, you can't take judicial notice about that. I mean, certain people would certainly dispute that to be the case. So this is some of the frustration that we should expect to feel with the nature of the Supreme Court is they're not going to go on a fact-finding mission. And this is an opinion, which I think any sane person would have, but there's a difference between a well-trusted opinion and a finding of fact from a court. Even if there's tons of evidence, which I believe there is tons of evidence, but they can't really mull over that evidence to reach a finding of fact that this was brought for the purpose of causing political damage. And if you can't have that as a finding of fact. You sort of have to put that aside as if it doesn't exist. And that's what the Supreme Court is going to have to do. So while I agree with everything Andrew Bailey is saying here, I think for purposes of pushing the Supreme Court towards reaching this conclusion, they're unlikely to be very moved by that because they'll be like, well, I don't know that's true. There's never been a finding of fact that that was the purpose. So how do we know that's true? And calling it transparent, even if it is transparent, is different than it being a finding of fact. So here's an interesting factual issue. As the former governor and former attorney general of New York, talking about here, Andrew Cuomo, said 2 weeks ago, if his name was not Donald Trump and if he wasn't running for president, I'm telling you that the case would have never been brought. So this is evidence. Realistically, I don't expect the Supreme Court to say that they can rely on that being proof. It's one man's opinion, and even if he's a significant individual who happens to be from the opposite party as Donald Trump, that's not an admission from the state of New York. If there was an admission from the state of New York, if Governor Hochul said that, that would be something. Perhaps. This lawfare is poisonous to American democracy. American people ought to be able to participate in presidential election free from New York interference. Again, and every one of us agrees with this 100%. This is not logic. That tends to be something that the Supreme Court is going to maybe. Perhaps. I'll withdraw that last comment. Maybe they will. The people ought to be able, yeah, maybe they will. Any gag order and sentence should be stayed until after the election. And again, those of you who joined late, I obviously want him to win. I think justice demands that this relief be granted as far as like what is fair and appropriate. And I'm sure as we're reading these papers, you're going to come to that same conclusion. There's a difference between what is fair and appropriate and what is allowable under the law, what's a legal argument. And I think that unfortunately, Missouri has little power here. And the basis as to why they're trying to assert that they have a right to intercede is somewhat stretched. Just being real with you. The court has original exclusive jurisdiction over this action under 20 U.S.C. 1251, which we looked at, because the dispute is both a case in which a state and party and a controversy between two or more states. Plaintiff state Missouri is a sovereign state, sues by and through its attorney general, Andrew Bailey. Dude is based. Missouri is standing to sue in the sovereign and quasi-sovereign capacities. Okay. Missouri is injured by New York's attempt to use its coercive state power. This is a key thing here. Let's focus on this here. Missouri is injured by New York's attempt to use its coercive state power to interfere with the ability of Missouri electors to fulfill their federal function and of Missourians to receive relevant election-related information. I'm trying to look at this and through the lens of a Supreme Court justice. So you're telling me that I need to take this case up and look at this case because your electors are not, because New York's coercive power is interfering with the Missouri electors' ability to do their federal function. I don't even understand how it has any impact on the Missouri electors doing their federal function. They can cast their ballots. They don't need him to speak to cast their ballots. I guess what you're saying is it's less likely the Republican electors will be able to do their function. But that's a political question. That's something that the court's not going to care about. Missouri has an interest in securing observance of the terms under which it participates in the federal system and not being denied its rightful status within the federal system. Observance of the terms? Is it just me? I just think I'm struggling to understand how you can observe it if he's not speaking. Does Missouri not going to go through the election process? I think the struggle is going to be real here. I'm not going to kid you. I think the struggle is going to be real. Again, I hate standing. I wish standing would spontaneously combust. But it is a thing. And it's a thing in every case. And the nature of their interest here so far, I'm not swallowing it so far. I'm just not seeing it. All right, we're going to skip past the facts. So, okay, because we all know the facts. Trump was convicted for stupid, ridiculous crimes. And yes, that was all unconstitutional. Everything about this was wrong, and the gag was wrongful. You all know this. Pattern of lawfare, we all know this too. They have to spell all this out for the court. Further background of criminal investigation. Yeah, he's definitely been attacked relentlessly, and it's been ridiculous. Let's get to the irreparable harm to Missouri and other states. Trump's conviction is very likely to be overturned on appeal. I believe this is 100% true. But I don't think that SCOTUS, unless they're going to overturn it themselves right here and now, which seems very unlikely, they're not even mulling that question over, I don't think they're going to say, yeah, we're assuming that this is going to be overturned. But by then, the constraints in New York has sought to impose on Trump to limit his ability to campaign will already have had their full effect. Missouri has a strong, judicially enforceable interest in its citizens and electors being able to hear Trump's campaigning free from any gag, under order, or other interference imposed by the state of New York. I don't know what that's you're trying to sell us on. What's the judicially enforceable interest? That's the problem. You do? And is that judicially enforceable interest only because it's a low-level crime? Is it only because if the charges were brought corruptly? I'm really struggling here. I'm not kidding you. I'm struggling. I'm struggling to find what the basis is. Occupant 42. Join us, Rambo. We're more not a cult than YouTube. Join us, become one of us. Join us. Join us. Join us. Join us. That's what the Rumble Ghetto is telling you. Join us. Join us. I apologize. That's pretty funny. Occupant 42. Talk to Ron about having Professor Jacobson do a legal insurrection interview of you and your ungagged Trump. Who's Professor Jacobson? Ron is his attorney and will get you over 100K. I don't know who Professor Jacobson is. Group must call mail Missouri AG when amicus is ready. I'd be happy to submit an amicus in this. But I have concerns about the viability of this. I'm not going to kid you. I have concerns. Off topic, the following with Joe Neiman of Good Lawgic has a better host attorney and Jewish example than DW's kind of a nebuch. Well, thank you. Than Daily Wire's kind of a nebuch. Well, thank you. The fact that Missouri's electors are not bound to one candidate, but are free to choose any presidential candidate to vote for. This is why. I know this comes up later. He brings it up later. So they can't do their function unless they hear him talk about these issues. All right. I hope you're right. Missouri has a strong judicially enforceable interest in its citizens' electors being able to hear Trump campaigning free from any gag or other interference imposed by the state of New York. For example, unlike most states, Missouri does not have pledge laws requiring electors to pledge to vote for a certain candidate. I don't know that anyone has pledge laws right now. If he's referring to the National Compact, that only kicks in once they have enough electors across enough states across the country. If you're unfamiliar with the National Compact, today being Independence Day, because it is here on the East Coast right now, Independence Day, this is a good time for me to inform you as to the commie bastards who came up with the concept of the National Compact and just how evil and corrupt any politician is who signs off on this National Compact, which is leftist, Marxist, un-American, completely gross perspective that likely will end up concluding with me ranting before I finish explaining to you what this is. So, if the sound of my voice rising you find to be disconcerting or bothersome or in any way irksome to you, you might want to either step away from your computer or transmitting device, turn it down, go walk off for a few minutes, because the topic of the National Compact, which is what he's addressing, I believe, with these pledge laws, is something that makes my blood boil. Leftist communists who obviously cannot stand our country, don't understand anything about what our nation is about, have no understanding of its rich history, brilliant insight of our founders, zero appreciation for the blessings of freedom that have been conferred upon them in ways that are far deeper than they can possibly conceive, how their rights are protected via this complicated and yet brilliant invention of federalism that our founders, who were thousands of times smarter than today's screeching idiots, decided to gift to these screeching idiots and whatever unfortunate souls those screeching idiots happen to breed out from into the next generation and the generation after that. The National Compact conceptually is a compact that has been signed by several states, which says that we, State X, are pledging that we will demand and compel our electors in our state to follow whatever the national total election numbers, whoever is the winner of the popular vote on a national level. So, what they are saying is our electors are not going to be chosen by people in our state, but we will say we are pledging to you that the electors are going to be, who are chosen, are going to be consistent with the national vote. So, if you live in state X and your state happens to vote for the Republican, but the Democrat wins the national popular vote, we will tell our GOP electors, go F yourselves, you have no say, and turn that slate of electors over to the Democrat in recognition of the popular vote. Why do I say that this is communist, leftist, bizarro, just disgusting compact? It's for the following reason. It's because let's understand what is happening here. Let us understand what is happening here. Your state votes for candidate A against candidate B. The popular vote is won by candidate B. You are now, as the leader of your state, the representative of your people, committing that in that scenario, whoever my state votes for, to hell with my own constituents, to hell with what they want or who they want to have leading them, we're going to just cede that away, throw that in the garbage, and give our electors over to the one who our state does not want, has been rejected by our state, and instead give it to the winner of the popular vote. Which basically means that, you're in the state of Oklahoma, you're in the state of Montana, you're in the state of Florida, whatever stupid state would sign off. And I'm not saying that any of those states have, because I don't believe that they have, but you're in the state of New Hampshire. So we're part of the National Compact. So what if our people here decide that they want to have the Democrat candidate? The Republican won the popular vote, so we're going to go along with and take the electors and basically give them over to the candidate that our state rejected. You are the leader. You're chosen. You are elected to be a state representative to represent the interests of the participants of your state. And what you are pledging, you're promising, is that in a situation where the will of my state is in conflict with the national will, I will tell my own state constituents, go to hell. I care more about people who live 2,000, 3,000 miles away from us than I care about you. You voted to put me in power. I'm your leader, and I'm telling you that even though you want candidate A, I'm going to give our electors over to candidate B because I signed off on some stupid freaking pledge which says that, your vote does not count if it's not part of the winning majority of the popular vote compared to some jackasses living off on the West Coast. So now I'm sorry, to hell with what you want, to hell with what you think is right for you, your values, your morals, your character assessments about these candidates has to be subjected to some stupid, crazy leftist on the other side of the country who basically said, because there's a whole bunch of crazy yahoos out there who are like, no, we're going to go out there and vote. And the way they conduct their elections, where they come up with these vote tallies, now you're subject to every state's most corrupt person, the most corrupt election that's being conducted anywhere in the state that says, hey, you know what? I don't care if we only have X number of registered voters. We're going to be stuffing this ballot box full of votes so that this way we get a national total, which comes out that our candidate is the winner of the popular vote. And that's going to force people 3,000 miles away from here who were stupid enough to sign off on this crazy communist manifesto invented type of plot of the National Compact, that now their electors, because of our stupid vote rigging, are now forced to join in and sign up with our candidate. How asinine is this? How stupid do you have to be? How much of a jerk, turncoat, crazy, I don't care about the people who elected me kind of person, individual would you have to be to say, I'm going to subject your vote to the national poll, the national outcome, which has nothing, and when will it kick in? When will it kick in? The only time it's going to kick in is if it's working against my own state. Meaning, if my state happened to be voting for the person who ended up winning, well, then the compact isn't having an impact on you. The only time it's having an impact on a particular state is when your state chose the loser of the popular vote. Because otherwise they're already voting, they're already going along with the winner if they vote for that candidate. So you are promising that I am signing that I am going to screw over my own state. How dare any political leader come up there, thrust into the thrones of power that you're now the ones who are deciding how your state's going to run, and you specifically sign a promise which says, I am going to screw over my own state. What kind of jackass are you? What type of un-American, what kind of crazy, stupid leader? Who would ever vote for someone? How dense do you have to be to encourage, to basically try and project this out to your state? This is a good thing. You know what's a good thing? Is I'm promising that whatever our state goes along with, I'm going to ignore that and just give it over to whatever some jackass in the state of Washington wants to vote for because they won the popular vote. Well, how did they win the popular vote? Oh, I don't know. They basically shipped in cartons and cartons of different ballots. We have no idea how the national vote total came about. We have no idea of the legitimacy of it. We don't know if they're checking the ballots. We don't know if they literally Or giving away ballots at their local Wendy's or your Taco Bells that they're basically sitting there saying, oh, let's all fill it out over here. We don't know if they're walking all over the place conducting elections in ways that we would deem horrifying in order to stuff that national total up into some crazy high, crazy stupid number. Well, all of a sudden we have 330 million Americans, and based on the vote totals that we're getting out from the West Coast, that all of a sudden it was like we end up with 400 million votes that are counted, and that's our national total now. And you signed a compact. Now you got to basically give up on whoever your state wants and sign up with us because we managed to stuff our ballot boxes over here where you had no way of knowing whether our vote totals are legitimate. What kind of terrible human being would take that power that their state gives them and says, we're making you our leader, and saying, thank you for making me your leader. I am now going to screw you. I'm going to screw you. And like when you bend over, I'm just going to be like shoving my fist in any type of, like, I'm going to be shoving in your eye sockets and your ears. I am going to be bending you over every way possible. Thank you. Thank you. Thank you for trusting me with your vote. Now that you trusted me with your vote, you have no vote anymore. You have no vote anymore because I just signed off on some national compact where I signed a pledge and said your vote doesn't matter anymore. That some vote, even if the vote totals were all accurate, that the vote of somebody who lives 3,000 miles away from you, whose values, morals, and perspectives on the world are completely different and opposite of yours, that they are every bit as important as you, as your opinions are. Wow. 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 That's the national compact. I'm not a big fan of it. This goes nowhere. Well, of course. They're talking about electors having a vote pledge for the popular winner in their own state, not the unconstitutional national compact. No, I understand that. I understand what Bailey's saying. He's saying we're not part of a pledge like that. Barlow's Alaska. Someone found a fire extinguisher. Joe's on fire. I warned you. I know. Look, I know certain topics are hot button topics for me. For example, unlike most states, Missouri does not have pledge laws requiring electors to pledge a vote for a certain candidate. Although Missouri electors typically cast their electoral college votes for the presidential candidate representing the same party that nominated electors, the electors remain free under Missouri law to exercise their discretion. Okay, so he wasn't really talking about the national compact. Well, we all learned a lesson about the national compact. No, what he was. Oh. Yeah. Okay. So what he basically is saying is that we have, what's it called? Our electors can vote for whoever they want, even if it's against the Missouri will. So what they want is really important, and that's why they have to be able to hear from the presidential candidate. Nothing at all to do with the national compact. All right. Well, look, it's an Independence Day. It's a good day to learn about how terrible the national compact is, even if it's got nothing to do with what Andrew Bailey's talking about. What was the term that they used for an elector who doesn't go along with it? There's a term which we heard about that. We heard about it a lot in 2016, late 2016. What was it? Not the disaffected elector, the faithless elector. faithless elector doesn't go along with the party vote from his part. So he basically is saying we allow for faithless electors. Since we allow for faithless electors, that they're not obligated to go with whoever our state voted for. Accordingly, our electors need to know who they're going to vote for. They need to hear from the candidates. Okay. Thank you, Elf. That's very kind of you. All right. New York has interfered with the ability of Missouri electors to obtain relevant campaign information, which they will use to decide which candidates to support in the Electoral College. The Constitution has its fullest and most urgent application precisely for the conduct of campaigns for political office. Missouri electors have a protectable interest in receiving this information. Really? Protectable interest? Walk me through it. I want to hear it. I really do. I hope you win. I'm just not really finding it so far. The informational injury at issue here, directly related to voting the most basic of political rights, is sufficiently concrete because the information would help them to evaluate candidates for political office. Now, this is really apparently a very important decision here. This is why we in Missouri are harmed, because our electors are the ones who are really harmed, and our electors have a protectable interest in hearing from Trump. How do we know this? Well, there was a case that's called Federal Election Commission versus Akins from 1998, where they said the informational injury at issue here, directly related to voting the most basic of political rights, is sufficiently concrete and specific because the information would help them to evaluate candidates for public office. I gotta look at this case now. Now I gotta look at this case. FEC v. Akins, 524 U.S. 11, 1998. The FEC seeks to remedy corruption of the political process. As relevant here, it imposes extensive record-keeping and disclosure requirements upon political committees, which include any committee, club, association, or other group or persons which receives more than $1,000 in contributions. Okay. I'm going to look for the word injury. Yeah. No, that's not what I want. Didn't you say the word injury in that quote? Let's look for concrete. The inability to obtain information that they claim FEC requires APAC to make public meets the genuine injury in fact requirement that helps assure that the court will adjudicate a concrete living contest between the adversaries. The fact that the harm is at issue is widely shared does not deprive Congress of constitutional power to authorize its vindication in federal courts where the harm is concrete. Informational injury here directly related to voting, the most basic political rights, is sufficiently concrete. All right. This is at least something. Now we got some case law. That's good. That's good. That's helpful. That's helpful. Again, I want him to win. I want them to win. That's good. That's something. Next one. Whether we agree with the FEC or the dissent that Congress lacks constitutional power to authorize federal courts to adjudicate this lawsuit. Article 3, of course, limits Congress' grant of judicial power to cases or controversies. That limitation means respondents must show, among other things, an injury in fact. A requirement that helps assure the courts will not pass upon abstract intellectual problems but adjudicate concrete living contests. There's no reason to doubt their claim that the information would help them and others to whom we communicate it to evaluate candidates' public office, especially candidates who receive assistance from AIPAC, and to evaluate that role of AIPAC's financial assistance might play in a specific election. Respondent's injury consequently seems concrete and particular. All right, this is the best case I've seen so far. This is a good find here by Andrew Bailey. This is a case I like. The inability to get information harms your ability to reach to vote properly. FEC v. Akins. This is a helpful case. This is a helpful case. Because Missouri's electors are state officials, boroughs v. U.S., Missouri has authority to sue on their behalf. That is especially true here because you could ask the question why the elector is not the ones bringing the suit. Missouri, that is especially true here because the identity of the electors will not be known until November, so obviously we have to do it. Nonetheless, prospective electors have been picked by the political parties in Missouri and are following the campaign, and 10 of those prospective electors will be selected in November. Several prospective electors selected by the Republican Party in Missouri have submitted affidavits detailing their interest relating to their expected official duties and listening to Trump talk in Missouri about the trial. Try to bolster your standing there. I like it. So they include exhibits H and J to establish that there are electors who are interested in hearing him talk about the trial. I like that. Good job, Andrew. There's currently a scheduled Trump campaign event in Missouri, but under the current gag order, Trump will be limited in what he can say. From conversations with officials, Missouri understands that scheduling more Trump events in Missouri has been difficult due because of uncertainty surrounding the impending sentence. There's uncertainty that we can't get him in here because of the impending sentence. We don't know what's happening with the sentence. Even if the Trump campaign could not visit Missouri, voters regularly follow social media, television, and news to learn about campaign speech conducted in other states. New York's orders similarly prevent Trump from freely campaigning in other states. Missouri's electors will be chosen by the people of Missouri through a popular vote. Those millions of citizens have the same interest in hearing campaign speech, and Missourians have submitted affidavits in this case explaining their interest in listening to Trump's speech in Missouri. The interests are harmed by New York's exercising its coercive authority to limit Trump's ability to speak. So why we're coming in here, parens patriae. In other words, this is how we're coming in here on behalf of Missourians, that the state can take a role of parens patriae, where they essentially are taking the parental role for those people who have no voice. Finally, New York's actions interfere with the associational rights of both electors and individual citizens of Missouri. As this court has recognized, representative democracy in any populist unit of governance is unimaginable without the ability of citizens to band together in promoting among the electorate candidates who espouse their political views. So when a state action negatively affects the party a voter works to support, then the voter indeed suffers harm. Under the First Amendment. Okay. All right. In essence, the harm alleged is an associational injury flowing from harm. The complaint is that state action has burdened the ability of like-minded people across the state to affiliate in a political party and carry out that organizational activities and objects. So would that apply if it wasn't election season? Is that going to end in December? I'm trying to play devil's advocate here. Here, the associational aim of Williams Maris is to elect Trump to the presidency. He's currently the leader of the Republican Party. New York's actions directly interfere with that associational aim. Okay. All right. All right. I'm going to go a little bit further here looking at Missouri's claim on standing. But the thing, Kim, is you don't necessarily have a right to hear people speak. The question is whether you specifically have a right to hear a political candidate speak. And Andrew Bailey is making a fairly effective argument to try and say that you do have a right to hear during election season from a significant political candidate. That's what he's trying to find. He's trying to find a basis to say why it is that under the law, Missourians have a right to force another state to bend their rules rather than allowing rather than allow Missourians to be harmed by that candidate's coerced silence. It's a very tough. Listen. If Bailey fails, dude is a beast. Okay, he's one of my favorite people in this country. I'm a big fan of Andrew Bailey. Guy's amazing. So many different things. Whether it was going after that district attorney, what was her name, Kim Gardner. Guy's been great. He's been great in so many different ways. He's the one who brought Missouri v. Biden. Or at least has been pushing for. I don't know if he was the initial one on that. He's great. Big fan of his. Very important individual in America's health. I just don't know that this claim has. I don't know if there's enough legal precedent that his claim here can survive. Let's look at page 2. We're going to talk about his standing. Let's look at his standing some more. See what he's got for us. What you got for me, Andrew? Show me the good stuff. Because original proceedings in this court follow the Federal Rules of Civil Procedure, the facts or purposes of motion for leave to file are the well-pleaded facts alleged in the complaint. Really? That's wild. Really? That's a new one. I didn't know that. The facts or purposes of motion? Okay. Court should grant Missouri's motion to file a bill of complaint because Missouri is standing to bring their claims against New York. This court has exclusive mandatory jurisdiction over the claims. On term, this court should exercise its discretion to hear the claims because this case presents constitutional questions of immense national consequence. And the important, time-sensitive, and straightforward questions of law warrant expedited review. Okay, here we go. Let's get to your standing. An original action must meet Article 3 requirements, which means it must appear that the complaining state has suffered a wrong through the action of the other states, furnishing ground for judicial redress, or is asserting a right against the other state which is susceptible of judicial enforcement according to the accepted principles of common law or equity systems of jurisprudence. Okay. When you're coming, so when we're going, so when we talk about, first of all, an original action, let me break this down for you. Original action means this is not a case that we're coming to you for, which is under appeal that was heard by a lower court. Its original place, the first time that this clash is being heard, is here. That's the court of original instance. Whenever you see that phrase and they talk about the original action, they're saying in which case was the case, in which court was the thing initially filed. So this one is a situation which initially filed in the Supreme Court of the United States. So it has to meet Article 3 requirements. It must appear that the complaining, so if you want to go directly to the Supreme Court and bypass all other appellate courts and circuit courts and things of that nature, it must appear that the complaining state has suffered a wrong, and that wrong has to come through the action of the other states, and it furnishes a ground for judicial redress, or it's asserting a right against the other state which is susceptible of judicial enforcement. So I have a right to force you that you, the court, have a right. I have a right against this other state that you, the court, have a right to compel them to follow. So either you wronged me and this other state wronged me and the court can remedy that wrong, or I have a right to force you to do something. This requires identifying either a sovereign or quasi-sovereign interest harmed, which means how is the state itself harmed by another state? That's how you have to establish a sovereign or sort of sovereign. Sovereign is a reference to the state itself. New York's action imposes sovereign harms the ability of Missouri's 10 electors to exercise their federal authority. Unlike the 32 states that have pledge laws, so over here in this context, some of you might foolishly think that pledge laws is a reference to the National Compact. No, its pledge laws are a requirement that your electors must go with the will of your state and follow the majority in your state. And you can't be a faithless elector. I'm okay with pledge laws. Those kind of pledge laws would say no faithless electors. I'm actually okay with that. Requiring electors to pledge a vote for a certain candidate. Missouri law permits electors to exercise discretion and discernment. So only 18 states like us allow for faithless electors. And vote for whomever they please. That means both the millions of citizens in Missouri and the 10 prospective electors will be paying attention to the campaign into November. Missouri indisputably has compelling interest in preserving the integrity of this election process. New York, and that's, so this is Purcell versus Gonzalez. I referenced Purcell earlier, but when they talk about the integrity of the election process, that's about, you can't change the law, like the election law. Like all of a sudden make people register by a new date, by an earlier date if they want to get on it. Like that's not fair because everyone was counting on what they thought the law to be. That's very different from silencing a candidate. I don't know the Purcell principle applies here. New York has interfered with this process by imposing constraints on the ability of one major party candidate, and only one, to campaign nationwide. New York impairs the ability of Missouri's electors to receive all information relevant to the decision to choose from who to vote. In the voting context, that is a classic form of injury. The informational injury at issue here directly related to voting, the most basic of political rights, is sufficiently concrete and specific. This is the case, by the way. This case right here, Federal Election Commission versus Akins, that's the case that, to me, if they get in there, this is the case which really is doing it. Because this part right here, This part right here. No, that's not good. I need thicker. This part right here. Wow, that's terrible. This is really the key. The informational injury directly relating to voting, the most basic of political writing. That issue here, directly related to voting, the most basic of political rights, is sufficiently concrete and specific. To me, this is the case that might get them in. I'm not saying it will, but if they get in, this is what did it. Constitution has its fullest, most urgent application precisely to the conduct of campaigns for political office. That's another phenomenal quote. There's another phenomenal quote. Should look nice. Fullest and most urgent application precisely the conduct of campaigns for political office. Okay. By injuring Missouri electors, New York necessarily injures the sovereign interests of the state of Missouri itself. If you harm our electors, because remember, we have to find a harm to the sovereignty of Missouri. So if you harm our electors' ability to cast their ballot, you're harming the state itself. Although presidential electors exercise a federal function, they are state officials. They act by authority of the state that in turn receives its authority from the federal constitution. Because they're state officials, the state can sue on their behalf. Andrew Bailey thought long and hard about this. He thought long and hard as how to create this lawsuit. This required some real artful thinking on his part. I don't know if it's going to work. I don't know if the ship is going to sail all the way across the sea and bring us into Valhalla, but there's considerable efforts that went into this. Because they are state officials, they can sue on their behalf, and the Missouri Attorney General is authorized by Missouri law to do so. It makes no difference that Missouri electors will not be formally selected until November. New York's actions impose harm now. That will make it more difficult for Missouri electors right now. When you're silencing him right now, that's harming. The harms thus will affect whatever is selected to hold that office. Whoever is selected to hold that office, and Missouri has standing to sue on behalf of those respective officials, no matter who those officials will be. In addition, electors have already been selected by the Missouri political parties that simply await formal selection by the voters in November. To exercise their votes later this year, they are paying attention to campaign speech now. Several of those prospective electors have issued sworn affidavits attached to the motion to expedite, expressing the high likelihood of becoming electors and their interest in being able to hear Trump's campaign free from New York. Why are they stuck listening to this stupidity out of New York? For example, Dean Brookshire, Thomas J. Salisbury, William Dane Rousseau have been selected by the Missouri Republican Party to be electors. So these individuals were selected by the Missouri Republican Party to be electors. They will become electors in November if Missourians choose Trump. In order to faithfully carry out their duties, all of them take steps now to be well informed about the policies, positions, and character of their candidates. Now we have affidavits from them where they say, I need to hear from him so I know who to vote for. Because the GOP's electors aren't sure who they're going to vote for. Or maybe they'll be faithless. Including by attending live political rallies, following news and social media coverage of campaign events in other states. All of them plan to attend as many Missouri Trump rallies as possible during the 2024 election cycle. Indeed, the Missouri electors will not be formally chosen until November reinforces that original jurisdiction is proper. But by November, all the harm Missouri currently complains of would have already occurred. Missouri has an interest in ensuring that prospective electors are able to receive all the information they need to exercise their legal function this year. By this argument, it would not, the relief that Missouri is seeking does not die on Election Day. It dies on Safe Harbor Day. We should look at that. If you're telling me, Andrew Bailey, that the reason that you need to have this gag taken off is because you won't be able to hear from them, your electors should be able to hear from them. Well, when are the electors casting their votes? It's called Safe Harbor. Is that when is Missouri? What date? Missouri cast elector ballots. What statewide election dates? What about the? You're not going to tell me what date? Remember how like they all have different dates? Like some have December 6th, some have December 16th. They all have their different dates. That's when they need the relief until, not until November. Not just until November 5th when there's a general election, because the faithless electors may decide to become faithless after November 5th. Right? I think that makes sense what I'm saying. And like New York's actions impose a quasi-sovereign harm in Missouri by depriving millions of Missourians of the information needed to vote. New York has similarly imposed an informational harm on millions of Missourians who will vote for the electors in November. The Missouri General Assembly has delegated authority to the people of the state by popular vote to choose the electors. New York's decision to impose restraints on Trump's ability to travel the country and campaign creates an informational injury on the people of Missouri, which, because it affects the most basic of political rights, is sufficiently concrete and specific. Like I said, the same case here, Aikens. They keep coming back to Aikens. This Aiken case may serve to give Andrew Bailey the audience with SCOTUS that he's seeking. Maybe. The court's recent decision in Murphy v. Missouri reinforces the theory of standing. Murphy v. Missouri is where Bailey was the case that I was railing against last week. There, the court concluded that a plaintiff can assert standing based on a right to listen theory, where the listener has a concrete, specific connection to the speaker, such as a consumer wanting to see advertisements for drugs that they purchase. Here, Exhibits A through F are representative sworn affidavits from individual Missourians who are considering voting for Trump in November. State-specific plans to attend a Trump rally in Missouri during the 2024 election and are concerned about the effect of the gag order and sentence will have on their ability to hear him speak. What is this that you said? They have a right to listen theory where the listener has a concrete, specific connection to the speaker. So since they're planning on listening to him speak, it's a little tenuous. Maybe. Not only do they want to attend rallies, but they also want to hear Trump's perspective on what happened at his trial, how he was treated by the system, and why I should still vote for him. So unlike in Murphy, where this court said the plaintiffs had not identified any specific speakers or topics, we learned from Murphy. We learned from what you said there. You said, these plaintiffs have no specific injury. These do have a specific. They want to listen to this lawsuit represents Missouri residents who have identified. So unlike that case where you said we haven't identified specific speakers or topics, I'm telling you now, here are the people. They want to go to hear him at this rally and be able to attend and not have him having the state of New York say, no, you can't attend. No, you can't speak on these topics. They're saying this is what they want to hear him speak about. They are thus just like the consumers who were permitted to sue over prohibitions on certain advertisements. You taught us, SCOTUS. I took notes. I saw how you slammed us last week. Now I'm meeting your standing requirement. This is what I was saying last week when I was assessing it. They told us what we need to get to. They told us the yardstick. Remember, you might recall, I was talking about how they create this yardstick so crazy high that like LeBron James would be on a fireman ladder that's like 50 feet up, doing pogo jumps and try to reach up to the bar that the Supreme Court set for him to reach standing. The bright side I gave you was they told you exactly what the path is. Now they just got to find a way there. Missouri's learned. We learned, all right. A Trump campaign has scheduled an event for Missouri for July or August. Campaign has plans for more events, but is running into logistics problems. Why? Because of the gag order and the impending sentence. So we can't hear from him. These people want to hear from him. They say they want to attend as many rallies as possible, and they can't hear from him. Campaign is currently unable to finalize further campaign stops in Missouri because even a sentence of probation would necessarily restrict Trump's ability to travel to hold and attend live campaign events. Even if Trump could freely schedule events in September, October, the gag order would limit Trump's speech at campaign events. Whether Trump is being unfairly targeted for prosecution by his general election opponent and allies of the opponent is, of course, highly relevant to Trump's pitch about which candidate voters should support in November. But on the gag order, what's going to happen? Can't speak. Can't do none. Silenced. Even the Trump campaign could not visit Missouri. Voters regularly follow social media, television, and news to learn about campaign. So he's got to be able to speak whatever he wants, and we can come in here as parents patriae. What is parents patriae? That's when a sufficiently substantial segment of the state population is injured. That harm becomes an injury to the state. That harm becomes an injury to the state itself. And the state can sue as parents patriae, rectifying its quasi-sovereign interests. Indeed, this court is how a political party can sue on behalf of voters. So all the more surely the state, which has a long history of parents patriae, that we can do that too. That's the interest in hearing. The interest in hearing campaign speech is widely shared among millions of Missourians. That does not make the injury generalizable. And this is one of the concerns I had, that if everyone's harmed, then no one's harmed. Theory that the court often employs. As when a large number of people suffer a widespread mass tort or nuisance, each of these individuals is separately and concretely injured. I like that Bailey is trying to knock this out, this argument, which I was concerned about. Indeed, that is the interest, that the interest is widely shared reinforces that a parent's patriae action is appropriate. Since all Missourians are harmed, that's why the parent comes in on behalf of all of them, rather than coming in here as individuals. The injury to individual Missourians is so widespread that it creates a quasi-sovereign injury to the state itself. And finally, They introduced we have the associational rights of both electors and individual citizens of Missouri. When a state action negatively affects the party a voter works to support, then the voter indeed suffers harm under the First Amendment, as do all other involved members of that party. That's from Gill versus Whitford. I'm not familiar with that case. Gill v. Whitford. What is Gill v. Whitford? I don't know what that is. Take a quick look at Gill v. Whitford. I'm landing my plane soon. If you're worried, if you're thinking like, oh, Joe's going to be here for like hours, no. I'm going to finish like this next 3 paragraphs and I'm wrapping up. So if you're worried about, your friends and stuff like that, I'm just telling you, start saying your goodbyes. Heading out to the bathroom and stuff like that. What are we getting at here? What are you looking for? If the gerrymander ravage the party he works to support, then he indeed suffers harm, as do all other involved members of that party. Oh, this is a gerrymander case. The associational harm of partisan gerrymander is distinct from vote dilution. Consider an active member, this is from Kagan in a concurrence. Consider an active member of the Democratic Party in Wisconsin who resides in a district that is a partisan gerrymander has left untouched. His individual vote carries no less weight than it did before. But if the gerrymander ravages the party he works to support, then he indeed suffers harm, as do all other involved members of that party. Okay. So he's trying to use that. When the state action negatively affects the party a voter works to support, the voter indeed suffers harm under the First Amendment. Wow. Okay. That's creative. When the essence of that harm alleged is an associational injury flowing from state action, the complaint is that the state action has burned the ability of like-minded people across the state to affiliate in a party. All right, he knows this is not a great argument. He knows this is kind of thin. This is very, very skinny legs. This is very skinny legs. Skinny legs, this argument. It's like a big, imagine like a big, fat dude and tiny little legs. Tiny little legs. That's what this argument is. Alleged harm. I'm trying to take from gerrymandering, associational type of things. It's creative. But this is like it's like thinking that attaching feathers to your arms are going to make you fly. I'm not buying this one. Sorry, I'm not buying this one. Since sufficiently imminent that this case is ripe. On June 25th, the trial court removed the part of the gag order concerning witnesses, but maintained it concerning counsel. That gag order is expected to remain in place until at least September 18th. Woohoo! More time. Each day that continued gag order limits the speech Trump can issue that is irrelevant to voters. Let's see. Why did he come up with September 18th? No, I didn't want to highlight this. I want to select this. So I should probably pause and talk about this for a moment. Dear Counsel, so this is Judge Marchand wrote this yesterday. Dear Counsel, I write to you in response to your recent communications. I refer specifically to the People's email of July 1, requesting permission to delay filing the sentence recommendation pending further guidance from this court. This above pre-motion letter of July 1 seeking leave to file a motion to set aside the jury verdict pursuant to CPLR 330.30 subsection 1 based on the Supreme Court's decision in People v. Trump, and requesting until July 10th to submit a memorandum of law in support of the motion. The People's letter dated July 2nd requesting a deadline of July 24th to file a response. The People's request regarding the sentencing recommendation was granted yesterday. Defendant's request to file a CPL motion by July 10th is granted. The People's request for a deadline of July 24th to file a response to the motion is also granted. The July 11th sentencing day is therefore vacated. The court will be rendered off calendar on September 6, 2024. Matters adjourned to September 18th, 2024 at 10 a.m. for the imposition of sentence, if such is still necessary, or other proceedings. So nice now. Why are you not imposing sentence? Why are you not imposing sentence? All of a sudden, he's being so accommodating. Why? Because all that mattered was 34 convictions. That's all that mattered. Once we have 34 convictions, that's all that matters. Nothing else. Nothing. That was so urgent. Couldn't push this trial. No. We got to do it now. Do it now. So the point is that based on this letter here, we can be fairly confident this gag is going to stay in effect until the 18th. So you might say to yourself, wait, so if he's not there till the 18th, so he's free to go. What's the problem? So they say, even if sentence is probation, Trump may be prohibited from leaving New York without pre-clearance from a probation officer. He would be required to regularly report to New York City's probation department. Could also be jailed immediately. All right. Well, this basically means that you have the gag, that you want the gag off like yesterday, but the sentencing, you don't have to worry. He's not going to be under restrictions until before September 18th of any kind. So, what are my thoughts? What are my thoughts on this? At the end of the day, I like the effort. I think that case, Federal Election Commission versus Akins, may get him in. If he gets granted cert, if they allow him to come in. Okay. Let me just conclude with these final thoughts for you. My personal interpretation of the Constitution is they are obligated to hear this case. Texas versus Pennsylvania tells us the Supreme Court disagrees with me, and unfortunately, until such time as the universe unanimously decides that I am their Lord High Commander, I have no sway currently or for the foreseeable future over the Supreme Court. So technically, it's not my opinion, but their opinion that becomes operable law in this country. Accordingly, they believe they read the Constitution differently than I do, seem to interpret that they have rights to say, we're going to close our ears and not look at your application of this dispute between these two states. Should we expect them to say, we're not taking this case? I don't want to hear from you. Go away, Andrew Bailey. Go away. Not listening. Should we expect them to do that? Given how they acted in Texas versus Pennsylvania, where they say, we don't want to weigh in here. about this election that just happened. That's the case of Texas versus Pennsylvania. It was in December of 2020 that Texas said, hey, we don't want to let Pennsylvania's electors come in here and dilute our electors. And here's the case of Bush v. Gore, where we say the Supreme Court recognized that it's a real, that we're harmed as a result of our vote, of one vote in a different place coming into the same election as me, if that person has no right to vote. And since Pennsylvania did their elections in lacking conformity with their own laws, these are not valid electors and they shouldn't be able to come in here. Supreme Court said, we're not listening. There was 28 states that supported Texas, and 21 states, that's like every state in the country practically weighed in as to whether or not, the rights of Texas versus Pennsylvania. What does the Supreme Court say? Not listening. I don't know what's going on. I'm not listening. We're not going to listen to your case. Go away. So we learn a few things from this. A, they feel that they can walk away from a controversy between states, even when the Constitution directs them that they must take it, even if it's something that's of national importance. And even if it's helping clarify something, that there's a circuit split, that all these different states disagree with what the law is, they can close their eyes and ears if they feel it's politically expedient to do so, which is very, very aggravating to me. That's why I went nuts in Texas versus Pennsylvania in a rant that I highly recommend you check it out. That being said, it's a standalone video. You can see it. That being said, why did they walk away from Texas versus Pennsylvania? Almost certainly because they were afraid. They're like, what is going to happen if we find in favor of Texas? We, the Supreme Court, will now be deciding the outcome of the 2020 election. And that's not a role we want to take. That is not a role we want to take, that we're deciding the outcome of this election. So we're just going to pretend that we don't have to listen to this case and walk away from it. I do feel that they're not crazy about taking Trump cases. They're more likely to take this case than Texas versus Pennsylvania because they're not determining the outcome of the election. Also, the nature of the relief that's being sought here is not overturning the conviction. It's just pausing everything. So they're more likely to be accepting of it. They're certainly not eager to take this case. That I can tell you. They're not eager to take this case. So I would not be remotely surprised if this case dies on the vine, doesn't get cert, even though I don't think it should require cert. Everything should be mandatory for them to take. But again, I'm not Lord High Commander. I can't compel them to take the case. I think there's at least a 50-50 shot this doesn't get granted cert. We'll just be like, leave us alone. Leave us alone. We already gave the whole immunity thing. Leave us alone. Leave us alone. We don't want to deal with this. There's a very decent chance that happens. If they do take the case, I think they have a decent shot, but the standing is the big issue. And the way they would overcome standing, I would not be remotely surprised if it falls 6-3 the way Murphy v. Missouri went. And they say, we don't think you have standing here to stop New York from passing, from embracing its own penal code the way they're doing it. It's very possible. I think Aikens might give, federal election versus Aikens might give them standing. The associational arguments I don't think are going to work for them. So we'll see. We'll see. But there's a really good chance that this doesn't, that the Supreme Court says we're not listening to this case altogether. Sorry I missed most of the show tonight, dear leader. Here's a little extra for squirrel food to grow out our stock until the election. Well, that's nice. Hey, thank you so much. I'm really wrapping up. You came at the very end, Barracuda. The very, very end. I'm just going to be checking up and see if I missed anything over. Tomorrow, I'm going to be doing I'm going to be having a locals live stream. I'm going to have a rally tomorrow. Should I do a rally? I don't know if I can do a rally. We'll see. Maybe I'll do a rally in locals. That's goodlogic.locals.com. Goodlogic.locals.com. And I'll tell you right now, until I sort this out, I'm giving everyone access. Feel free. You can sign up there at locals. And I told everyone, you want to sign for free? The code is not at all a cult. And that code is going to die. When's the deadline on that? There's a bunch here. Joe, not at all a cult. What the hell do I do with all the goats and chickens now? Entry required saying, wish you would achieve your content on local. Archive your content on local to protect you from YouTube. I don't know how that would help. Good morning, all. 4th of July for the New York and Sweden. Oh, that's so nice. Thank you, entry required. Thank you so much. So there you go. There you go. That's my show, and I'm sticking to it. I'm wrapping up right here. I thank you all for joining me. I hope your 4th of July is phenomenal. Spend some time with family. Spend some time appreciating the blessings. A lot of people talk about white privilege. There's no such thing. There is pretty privilege. That's very real. There's pretty privilege. It's very, very real. And there's American privilege. And that is very, very real. And hopefully we're able to maintain enough about what makes America America that America retains American privilege. From this generation to the next and the one after that. I only hope we do our part for that. And with that, I wish you all the happiest of Independence Days. Happy 4th of July. That applies whether you're white, you're black, you're man, woman, whatever race, gender, creed, Apollo creed, religion, whatever your intersectionality is. I don't care if you're short, you're tall, you're fat, you're skinny, blue-eyed, brown-eyed, green-eyed, purple-eyed. Yeah, purple-eyed is pretty cool, actually. I wish you the happiest of Independence Day. Happy 4th of July, my friends. Don't eat some bugs. Don't eat some bugs. Good night, y'all, and Godspeed. Coin auction. Totally forgot about that. Soon. It's coming soon.